Hello, this video is about the development and the methods of interpreting English law, which has developed organically over the last 1500 years or so. The English law, of course, is the basis not only for the law in England, but for the law of many other countries around the world that were formerly in the British Empire or who've chosen to adopt our system of law because they think it's a good system. It's a two-way thing, of course. Judges like Judge Benjamin Cardozo, for instance, in the US, have often said things which have related back to England and changed the law in England. We'll begin, because it's the best place to begin, in the Dark Ages, just after the collapse of the Roman Empire. The Roman Empire, of course, had its own system of laws. It was highly codified and highly bureaucratic, and it collapsed not because it was invaded by barbarians who had no interest in maintaining a civilized society, but because those same barbarians, once they took over the cities that they wished to have, decided to get rid of the systems of law and the bureaucracy that made it run, that made it possible. There were remaining Roman principles. An example of something that's changed slightly but remained from Roman times is the system of juries. Juries in Roman times were lay people. They weren't attached to the case, they weren't involved in the case, they weren't legally qualified, but they were brought to court for things like land law cases, where people didn't have accurate maps, they weren't sure where one piece of land ended, another piece of land started, and so people who'd lived there locally for a long time would be brought in and they would give their opinion as to who owned what land. The Carolingian kings had juries as well, of course, again lay people by the same name, brought it to the court, but the Carolingian kings were the first people to develop it as a system where the society itself, the jury of peers, decide guilt in a criminal case. In and of itself, that did come across to England. Offer of Mercia was well known to communicate with Charlemagne, the most famous of the Carolingian kings, and Offer of Mercia brought the system of juries across even before the legal system had properly developed in England. During Saxon times, the period from about 600 AD to the end of the first millennium, a system of generally accepted law didn't exist in England. There were debates in mooting halls, the halls in the centre of Saxon villages, and village to village the law would change quite dramatically. It was an adversarial system. The Roman system had been, for all the likes of people like Cicero, it had been an inquisitorial system in some ways, where you would check the facts and then try to see what law applied to them, rather than an adversarial system of arguments. I know they did have their advocates as well, but the mooting system and the legal system in Saxon times was certainly adversarial. The real change to that system, or the change in it being a small village based system, came just after the turn of the millennium, during the reign of King Canute, the king famous for sitting on the beach and showing that he couldn't turn back the tide to deny the fact that he was a deity. During that time, there was a famous speech which is the inception of the common law system by Archbishop Wulfstan of York. The speech, Sermon Lupe ad Anglos, the sermon of the wolf to the English, or to the sheep, sometimes interpreted, described how Jesus had died for sins, and it described the way that the structure of society at that time, which had very much fragmented, and how some of the practices in some of the villages were entirely inappropriate for any system which was going to survive. You can find the speech online. I'm sure you can find it and read it if you wish to. It was the implication of the creation of this system that led very much to Canute's fame. It created a steadier society, and one of the main factors in that steady society was the system of stare decisis, the doctrine of stare decisis, which is the doctrine of standing by that which has been decided, or precedence. Precedence means that if a decision has already been made in a similar case, when you arrive in the court, for a decision, the same decision will be made, and then that way the law becomes common to all because the same decisions are made in similar circumstances. This creates legal certainty because since these things are done properly and in public, people get to see what the law is, what decisions are made, and it creates stability because from village to village you know what the law is. When judgments are given in this system, there are two main factors in the judgment given. There is the ratio decidendi, which is the reason for the decision, which is very much tied to the facts of the case. And often a judge, when giving a decision, will talk for a long period in a way which will explain to those people in future who read his judgment what reasoning he had behind it. And those things that don't apply directly to the case, but a part of his reasoning, are the obiter dictum, or otherwise speaking. Now, values in and of themselves can, of course, be discussed without facts. Philosophers do it all the time, whether ethical values, mathematical values, doctrinal values. The law is very much based on doctrinal values. But it's better in all cases to apply some facts, even if it's just an analogy. To take our imagined scenario, we have a young defendant, we shall call him Peter Rabbit. Peter Rabbit's a larcenous young character, well known in the area, and he's been in the garden of a farmer, Mr. McGregor. Farmer McGregor. He hasn't stolen anything yet, but he certainly has been in and out of that garden quite a bit. And Mr. McGregor is most concerned. He doesn't want him in the garden. He doesn't want him on his farmland at all. So Mr. McGregor, perhaps thinking that Peter is a person and because he wears clothes, has decided that he shall go to court to seek an injunction. This is a better method than seeking immediate damages. The damages are very little, and certainly if the injunction is then broken, then the results will be far worse for young Mr. Rabbit. In the court, Mr. McGregor gets his injunction, and Judge Bumptious gives the verdict. In it he says, "I grant the injunction. I am most certain Mr. Rabbit is unlawfully trespassing on Podden McGregor's land. I understand his concern, and would just as quickly grant the injunction had Mr. Rabbit been climbing onto the back of the van in which Mr. McGregor sometimes temporarily stores and transports food." There's two parts to this judgment. The first part is clearly that he says he grants the injunction and that he's more certain that Mr. Rabbit is unlawfully trespassing on the land. That is the ratio decidendi. He has said that he thinks it's trespass for Mr. Rabbit to be on his land in these circumstances, and on that basis he's granted the injunction. The other part, the part where he says, "I would have just as quickly granted it had he been on the back of the van," weren't the circumstances of the case. They were otherwise speaking, in which he was explaining that he thinks the law should apply elsewhere. They aren't part of the precedent, but they may be used as persuasive argument later. A few months later, a young Miss Puddleduck comes along. Miss Puddleduck isn't larcenous like Mr. Rabbit. She's generally just nosy. Miss Puddleduck is wandering along and walks onto the back of the van of Mr. McGregor's neighbour. We'll call him Mr. McNeighbour. Now, Mr. McNeighbour doesn't want Puddleduck on his van. He doesn't dislike her particularly, but he doesn't want her on the van, and he knows she's not there to do any harm. But he'd prefer she just stayed off his van. So he goes to court to seek an injunction in the same way as Mr. McGregor did. At the court, Mr. McNeighbour's counsel might turn round and say, "Well, in the previous case, I think you'll find that Judge Bumptious turned round and said that he would just as quickly grant an injunction had he been on the van as he would on the land." That would be their argument. At the same time, the counsel for Miss Puddleduck would turn round and say something like, "Well, these cases can be distinguished. They are certainly different. I mean, that was merely obiter dictum, and this isn't land, it's a van. She's not necessarily up to any harm. She's just nosy. It is inappropriate to grant this injunction." The judge might look at both arguments. He might decide the law is the law, and this has been well described perfectly by Judge Bumptious, and apply the law in that way. Or he may turn round and simply say, Well, it would be frightfully harsh for Miss Puddleduck to suffer the same consequences as young Mr. Rabbit, when young Mr. Rabbit seemed to be up to no good, and Miss Puddleduck is simply nosy. He may decide either way, and whichever way he decides will then be the law as it applies to people trespassing on vans. There are other things that occur as well in that become precedent within cases. Those are legal definitions. An obvious legal definition would be the word obvious. Obvious in its normal meaning is what is immediately apparent to all. What can be seen without much examination. Obvious in the legal system is something quite different. Obvious in the legal system is something that can be inferred based upon all of the facts when they have been established and agreed by both sides. The next event was 1066 in the Norman Conquest. William the Bastard, or William the Conqueror as he's now known, instigated the separation of the church and the law, the state. Not because he wasn't a religious man and didn't have respect for the church, but because he wanted control of justice. The system itself wasn't codified until 1189. He also instigated a system of lords throughout the country. These lords had power, but they also had duties. They had duties to ensure the welfare of the people under their areas. This was so those people would be fit, loyal, healthy, and ready to serve the state and the king when they were needed. Any lord who was tyrannical and worked against this idea would fall foul of the king. It was a duty that was held seriously. The King's Court was temporal in nature. It was a court that dealt with those things that were physical damage to people, assaults, etc. The clergy continued to cover things that were more spiritual and were merely considered sins, though they would have damage themselves, things like libel. The King's Court, as well as covering those physical damages, would sometimes cover the spiritual damage as well. If you and your friends beat somebody up in the street, you'd pay damages for having assaulted that person in the street, and you would often pay assault damages for the loss of standing of that person in society because you'd assaulted them in the street. The system was very much based on damages. The next event after that was the Crusades. At a time when life was short, when people could die very easily, very young, and the afterlife was thought to be eternal, the Crusades were irresistible to those people with the wealth and power to go on them. So all those people with wealth and power all buggered off to Jerusalem. This left a vacuum in the state and in the country and in control itself. And in 1195, magistrates started being appointed. These were lay people who were guided often by the church and other bodies in the law, but who made the decisions at a local level when offences occurred. They kept the king's peace, but they weren't called justices of the peace until 1361. There was also a hierarchy of appeal which appeared, where people who disagreed with the magistrate's decision could sometimes seek another decision in the King's Court. There came to be a system of what's called juridification. Juridification is where you follow precedent rigidly without any real attention to the facts of the case, to those things that really should be considered on top of merely the law. This strict adherence to precedents and juridification led to injustice, which worked against the fairness of the law and the principles under which it had been formed. Around the year 1200, the Courts of Chancery began to function as the final court of appeal. Once you'd been through everything, including the King's Court, and a decision had been made on the law, you could go and seek a merciful, just remedy through the Court of the Clergy. These people were well guided and well knowledgeable in law, of course, themselves. You had to exhaust the legal system first, then you went to the Courts of Chancery. Of course, natural justice based on merely on fairness, can be imprecise, and imprecision itself works against the steadiness that was produced by precedent. So they came to formulate over the centuries rules, maxims of equity. These maxims of equity were guidelines as to when you could depart from precedent. Of course, written as rules, they need to be interpreted, and they were often interpreted in case law, which became precedent that applied to the maxims of equity. In 1215, England's first statute, the Magna Carta, was written. A statute is something that is either done by the Crown on behalf of the Crown, a written document which guides the law. They've been regular since the reign of Edward III and are now referred to as Acts of Parliament. The Magna Carta didn't reduce jury trial. As explained earlier, that had been around since the 7th century. Well, the 8th century certainly. It did introduce the idea of habeas corpus, that nobody should be imprisoned without reference to law, which meant that they were awaiting trial, or without a trial themselves, either a trial by the king or a trial by jury. This principle is essential to law. It's essential to the freedom of men that they should not be imprisoned without law. There are three main methods for interpreting statute. The main methods being a literal interpretation, where you take the words exactly as they're written. This, of course, is a very bad idea if the statute's been poorly written, and can produce very unfair results. There is the purposive method, sometimes referred to as the mischief method, and sometimes referred to as the golden rule, where you look at the purpose of the law and you interpret the statute for the purpose you believe it was intended, to end the mischief, and to make sure, in golden rule terms, that interpreting literally doesn't end with it working against the idea of law. And there is the circumstantial method, where you look at the circumstances of the case and how the law should apply to those circumstances. Of course, when looking at how the law is intended to imply, people could refer to Hansard. Hansard is a record of everything that is said in Parliament when discussing the creation of Acts of Parliament. It wasn't until 1979 that a member of the judiciary admitted to reading Hansard in a case, and that was Lord Denning in the case of Davis and Johnson. And it wasn't until 1993 that a member of the judiciary in the case of Pepper and Hart actually admitted that he'd read Hansard and it was part of his decision-making process. It is now widely accepted that judges will read Hansard as part of their decision-making process to see what the law should have meant. As said earlier, the damages for cases at the time were usually the payment of damages, and, of course, in rare circumstances, people could be put to death. Sometimes people would be subject both to the payment of damages, everything they owned, and to being put to death. In those circumstances, people may avoid trial, or may have avoided trial, by simply choosing not to plead when asked, do you plead guilty or not guilty? When people did this, the court persuaded them to make a plea. They persuaded them by something called pena forte et jure, the force of force over time. They put a weight on their chest, and the weight would gradually increase. Sometimes it would take people 5 days to be crushed to death, and they would choose not to play. Sometimes people would change their mind. For those people who withstood this terrible torture, they did have the advantage when they died that, first of all, they died innocent in the eyes of the law, and some believed in the eyes of God, and secondly, that it would mean that their widows and children were left with something. They weren't left penniless. Torture itself had been widely accepted in Roman times. In fact, it had been insisted on when slaves gave their testimony. A slave could not give a testimony in a Roman court without being tortured. Sometimes the torture was minor, to say the least, simply so they could say the slave's been tortured and is telling the truth. It was very much phased out in English law. It's became something that was thought to impinge greatly upon people's freedoms. And you'll find that over time, what happened when people refused to plea was that they were simply entered a plea of not guilty. Those of you who remember that when Saddam Hussein appeared before the International Court will remember that he refused to recognise the court, refused to plea, and the judge simply said, "We shall enter that as a plea of not guilty." The next major development was the development in modern times of judges of note who gave advice on things in law whilst not being party to any case, and those would later be considered as being similar to arbiter, persuasive, and maybe used when the case arose. Judge Edward Coke in the 17th century was the preeminent lawyer. He'd made comments about the king and the law. He'd made comments about the importance of parliamentary sovereignty. Though he had, what he'd mainly argued for was that the law should be separate and independent from control by others, so that it may serve merely to serve the nation and the public as a whole, and that service to the nation and the public was more important than service to the king. He was duly sent to the Tower of London. Whilst in the Tower of London, he wrote his third instrument of law, his thoughts on the law, and part of this third instrument was his definition of murder, which is his enduring legacy as a jurist. Murder is when a man of sound memory and of the age of discretion unlawfully killeth within any county of the realm any reasonable creature in rerum natura under the king's peace, with malice aforethought, either expressed by the party or implied by law, so as the party wounded or hurt, etc., die of the wound or hurt, etc., within a year and a day of the same. The year and the day part was removed by statute in 1996. It had its own statute simply to do that. But otherwise, the definition endures, as does the idea of learned opinion. Learned opinion are those opinions by those learned members of the judiciary who aren't involved in anything, but who decide to release these things, and they can later be used when the circumstances arise. Frequently they are based upon the idea that the circumstance may arise. The 17th century also included many other tumultuous events that were the precursors to the Civil War. One such event that has lived in infamy was the Star Chamber. The Star Chamber had existed for some 200 years. It had been a private chamber for the king and his closest advisors. Only the king and his closest advisors were allowed to enter it. It started being used as a court where there were no indictments on record, no witnesses, statements were in writing, the statement of the defendant had been written, and it had to be signed by his legal counsel, which he had to have, and if it wasn't signed by his legal counsel, it wasn't accepted. The response, whether or not the defendant was guilty or not guilty, had to be in writing, and if it wasn't signed by his legal counsel, it was considered that he hadn't pleaded, and in those circumstances it was considered that he chose to plead guilty, quite apart from the previous methods that had been used. It was in secret, and like many secret courts, that was its major problem. The law itself, for it to function properly, needs to be seen and available so people understand what the law is, and so they can see justice being done, and it acts to stabilise society. The Star Chambers are frequently used now as an attack upon any impropriety or misuse of power in private, and they should well live in infamy. Another judge at the time was Judge Jeffreys. Now, Judge Jeffreys himself was known as the hanging judge. If you would appear before Judge Jeffreys, it's almost certain that he would not only find you guilty, as he believed the state wished, usually, unless the state had said otherwise, but that he would have you hanged, no matter what the offence was. This type of injustice doesn't go unrecognised by the public or unpunished. And at the time of the Glorious Revolution, Judge Jeffreys was captured by the mob. He was imprisoned in the Tower and he died not long afterwards, and that may have been due to the injuries he received from the mob who wished to hang him. Formal records started or are most likely to be found from the times of Judge Cook. There's two reasons for this. One was the increased use of printing presses, made things more available, made things more likely to be printed. The other thing was that Judge Cook wished to standardise the courts and the law, and in doing so he would frequently go through older cases, take what he wanted from them, and then dispose of them by fire, especially if he disagreed with them. So older records were in large part destroyed by Judge Cook. Now Cook had importance, much importance. He's he's essential to the development of law in this country. He's essential to parliamentary sovereignty. He's willing to stand out and argue. But he was also a human being. It could be said that the first thing he did when he was released from the Tower of London and allowed again to speak on public matters was to speak in support of the King. As the number of records of different cases increased, the judgments that were recorded were frequently shorter and they were more widely distributed. This led to greater juridification, which was something that was recognised by many in the judiciary, but was often seen as something that could be solved by the clergy when it reached the Courts of Chancery. In 1873, and revised in 1875, the Acts of Judicature came into place. These introduced the maxims of equity, the rules of fairness, and the precedents that applied into the English legal system. From that day forward, the rules of fairness would be listened to in lower courts, they would be considered, and people who were representing people could argue for courts to leave precedent on those occasions. It also meant that the House of Lords became the court of final hearing. The next event that really affected the law in this country also affected the House of Lords. When Asquith was Prime Minister in 1908, Lord George, the Chancellor of Exchequer at the time, introduced something called the People's Budget. The people were suffering most harshly at the time. There had been austerity measures which always lead to people suffering and never benefit the economy. And the act, or the budget that was going to be introduced, was intended to tax the rich to help the poor. The lords, who were all hereditary, as in their family had been lords for hundreds of years, all very rich, all disagreed, and it wasn't going to pass through the Lords, as was required. This was a real problem. Most people could see how badly the people were suffering. Most lords were entirely separated from the people. In 1911, King George V, who could also see this and was being advised by Parliament, told the Lords that if they didn't pass new legislation which prevented them using or misusing this power, that he would fill the upper chamber, the House of Lords, with Liberals. He would fill them with Liberals, hereditary Liberals, so never again would the Conservative people hold power and sway to abuse the power and sway. This threat was taken seriously, and in 1911 an Act was passed which meant that the longest an Act of Parliament from the Lower House, the House of Commons, could be held up in the Upper House, the House of Lords, was 2 years. And that if it had been held up 2 years, it would pass into law anyway without the Lords' consent. This was changed again in 1949 when it was reduced to 1 year. Just after the Second World War, the Labour government at the time would try to introduce measures which would privatise some national industries. The Lords didn't like it because they owned and made profits from those industries, and the Labour government reduced the waiting period so they could get on with what it needed to do to help the country recover from the Second World War. Parliamentary sovereignty was pretty much fixed by these decisions, and it was something that was well established or most recognised in the case of the Burma Oil Company. During the Second World War in Burma, our armies and navies had done everything they could to destroy the Burma oil fields so they didn't fall in the hands of the Japanese. There had been an agreement at the time, at the end of the war, from Churchill's government, the damages would be paid by this country. It was an agreement by Parliament, and it was a decision by Parliament. The War Damages Act of 1965, which was passed by the Parliament, worked retrospectively. Not only did it say that damages shouldn't be paid for those things that were necessary to win the war, but it said that working retrospectively, damages wouldn't be paid where they'd previously been promised. Burma Oil got no damages. The major event of the 20th century, politically, economically, socially, legally, was the rise of Nazism. Despite them choosing to call themselves nationalist socialists, there was nothing socialist about them. They did take money from people, but it was for private benefit, for their friends. Some people got very, very rich under the Nazis. They were corporate in structure and function, much as Mussolini defined fascism in Italy. They were so corporate in structure that when the SS started using camouflage uniforms, they patented camouflage uniforms, and other parts of the German army couldn't wear camouflage without paying the SS. The SS, of course, being a corporation, had somebody at the head who was making a profit from it. On top of that, media was developing, newsreels, etc. Media was very important in the rise of Hitler. Hitler was a charismatic man. I don't know if you'd describe him as likeable, but he was certainly somebody who was admired by people, and he was very much properly portrayed in the first major media campaign of the 20th century. This meant that he swept to power without people fully understanding what his principles were. That's part of the reason why he declared himself a socialist when he wasn't. That's part of the reason why he used to refer to religion when he wasn't religious at all. He simply knew that religion could be used. Obviously, with what the Nazis did, and you can find out what the Nazis did if you choose not to ignore the people, if you choose to ignore the people who claim that there was no Holocaust. You can find out what the Nazis did everywhere. There are still lots of books written about it. It was a concern. There was real concern about such government. Obviously, they were elected by the people, democratically elected. They had the power to make the laws in their own country for those people. But the laws they'd made were certainly aberrant. Two things were done to deal with this problem of elected governments which do things which are inhuman. The first one was the Nuremberg War Crimes Trials. The Nuremberg War Crimes Trials dealt with the atrocities of the Second World War, found people personally responsible in a way they don't seem to be personally responsible today for things, and said that there should be no more war for profit, which obviously there isn't anymore. The second thing was a team of eminent lawyers, widely knowledgeable in the history of English law and of English freedoms, went across to Europe. The function of these lawyers was to take those English freedoms, which were respected around the world, and to create a system in which those English freedoms were the basis of the legal systems in other countries. This was the European Convention of Human Rights. It was a treaty, and being a treaty, as treaties had since the Middle Ages, it held precedence over everything else. It was more important than national law because you'd agree to do these things with other countries. and the only thing you could do other than abide by the treaty was to leave the treaty altogether. England became a signatory to this treaty in 1952, and it was thought that it wouldn't do much to change the English legal system. It covered those things that the English legal system had established were essential and important for society. Things like freedom of religion, freedom of political ideas, freedom of family life, freedom of property was included in some way, freedom to be apart from torture, which was the only inalienable right, which should never be breached, freedom of imprisonment without charge, and it was thought that it wouldn't change anything in England because England had all these freedoms and it cherished all these freedoms, and indeed had just fought a war with our allies for these freedoms. Its application, however, was purposive. That is, it was for the purpose intended. In Europe, rather than purely based upon the precedent system, they had a system where their laws were looked at always purposively and encouraged to deal with the purpose first. So it was tended towards rights and values, though it also included precedent. Values in themselves being things that may change over time, but hopefully the inclusion of precedent and of codification meant that they would never change so much that human rights would be ignored, and therefore that the problems that had occurred in the Second World War wouldn't occur again. In 1966 there was a practice statement on precedent made by Lord Gardiner, the Lord High Chancellor, on behalf of the House of Lords. Their Lordships regard the use of precedent as an indispensable foundation upon which to decide what is the law and its application to individual cases. It provides at least some degree of certainty upon which individuals can rely in the conduct of their affairs, as well as a basis for orderly development of legal rules. Their Lordships nevertheless recognise that too rigid adherence to precedent may lead to injustice in a particular case, and also unduly restrict the proper development of the law. They propose, therefore, to modify their present practice and, whilst treating former decisions of this House as normally binding, to depart from a previous decision when it appears right to do so. In this connection, they will bear in mind the danger of disturbing retrospectively the basis on which contracts, settlement of property, and fiscal arrangements have been entered into, and also the especial need for certainty as to the criminal law. This announcement is not intended to affect the use of precedent elsewhere than in this House. I'm unsure as to why their Lordships decide to make this statement. There were already methods for departing from precedent. They already had the power to do so. It was one of many measures in the late 60s at a time when this country was, for the most part, for most people in this country, at its most successful. It was enjoying prosperity, and it was enjoying prosperity at the lowest levels. The issues that happened in the late 60s, and more important in the 70s in this country and what they developed to, probably deserve a series of videos in themselves. Lord Denning, famous for departing from precedent himself, immediately made efforts to try and apply these rules to the Court of Appeal in one way or another. He made effort in many different cases. I'm sure you can find the cases if you wish to look for them. I think that it's expected, and we'd all expect, that in times when there's going to be an injustice, that members of the judiciary will act against the possibility of the courts leading to injustice. I think that any judge should do that, even down to magistrates, and face the risk that they will later be punished for doing so. But there are, of course, those are based upon people's individual values. I'll probably make another video that will discuss individual values later. Values change from person to person, and sometimes they change from generation to generation. And it's the solid ideas of the laws we have in place and precedent which tend towards fairness more than abstract ideas of values. Not to say that values should be ignored. It's difficult to decide whose values are right, though. Post-war, of course, as well as links in other areas, and as well as the Convention on Human Rights, there had been attempts to try and increase the links in trade, the links in culture between the countries in Europe, in the hope that they would decrease the likelihood of another war. There had been war after war in Europe. In 1956, the European Cup started in football. In 1956, they also started the Eurovision Song Contest. And in 1957, Belgium, Netherlands, Luxembourg, Italy, Germany and France formed the European Economic Community, a community which would allow for free trade and free movement of people and goods between those countries. The strength of such a union was the strength of the union compared with those outside the union. This free trade was a very good idea if it meant that you then grouped together as a group of 6 nations and imposed tariffs on those from outside those nations and protected the trade within those 6 nations. It was the strength of tariffs that was the strength of the European community, the European Economic Community. Whereas the European Convention of Human Rights had its own court, the European Court of Human Rights, the European Economic Community formulated its own court to ensure that free trade and free movement of goods would happen between nations, and this was the European Court of Justice, the ECJ. The major case in early years, and probably one of the major cases of all time in that court, is the case of Van Genderloos in 1962, which established the rights for those free movement of people and that people would be treated equally in all countries. There was also a directive of 1971 which established that people would receive equal benefits when they moved from one country to another and would be not be treated as foreigners in those countries. In 1973, with those rules already in place, Britain, the United Kingdom, chose and voted to enter the EEC. They chose to enter the EEC to benefit from the ability of negotiating as part of a larger group for tariffs with countries outside, and to benefit from the free trade with those other prosperous countries in Europe. The EU is now a European Union, and it has 28 members. In the last 40 years, there's been a marked shift to the right in politics, in political discourse. Those ideas that once were thought abhorrent to even people who considered themselves conservative, they were once thought too far, too right-wing, too similar to the Nazis, are now accepted, circulated. In some ways, they're even taught to kids. There are children's shows in this country where people are taught to do things like be the best liar, where they're taught to do things like make the best profit regardless of who else is around them. And those things are becoming something that is taught as part of the culture. With this move to the right, there has also been an increase in legislation which is of a more right-wing nature, and an increase in cases that have went to the European courts to be argued against. In 1997, New Labour, I call them New Labour to separate them from Labour, the old Labour, came into power. New Labour are very much the same as neoconservative or neoliberal. They're all the same idea. They claim to be the new version of that particular grouping's philosophy, and all of the new versions are the same thing. In 1998, they introduced an act, which was the Human Rights Act, which would introduce those ideas of the European Convention on Human Rights into English law. Of course, we'd already had them introduced since 1952, and they'd been in our law before then. We already agreed to abide by them, but it was claimed that this was now human rights for the people of Britain. What it did in fact do was mean in a system where you could only go to the European Court of Human Rights if your case had not been considered on the basis of human rights in your in your member country, it meant that those cases now had the opportunity to have the human rights issue heard. And even if the human rights issue was ignored somewhat in the country, you could then find it very much more difficult to go to the European Court of Human Rights. The next major thing that was done, amongst many things that were done by that particular government, was in 2004, Peter Mandelson, who was the Hartlepool MP, was made the Commissioner for the EU. He was very interested in globalised free markets, and he argued for free trade and the removal of tariffs from countries from outside of the EU. And the tariffs have been removed largely. And that has meant that we no longer have the benefit of negotiating as one body. And we have to compete with countries like China and hope that they treat their workers in China and India and Bangladesh as well as they treat the workers in this country. Other things that have changed slightly is that the House of Lords changed its name, its name as a court to the Supreme Court, and there have been other minor law changes. The law changes all of the time. As I speak this, somewhere in a court in this country, there could be a judge saying something as part of his judgment which will drastically change even what I have said today. That's why you need to know how to interpret the law when you read it and how to research it. I know I've included nothing really on how to research it, but I'm sure you understand from what I've said the thing to do is to read the cases and to read the statutes. And also the statutory instruments, those things that come from statute. In summary, when you're looking at the English law, the things that need to be looked at is the precedent involved in the law you're looking at, how equity should apply with the law you're looking at, how fairness should apply, how the statute, if it is, should be interpreted, not necessarily just as it's written, not literally, and of course those international treaties that may affect the way it's looked at. There's general principles apply to other systems and other nations. Our law is similar to other countries. Other countries have things to add to that. We have an unwritten constitution which guides us. In the US they have a written constitution which should very much be looked at if you wish to look at how a law should be applied. I hope this has assisted those who like to look at the law. I hope to chat again soon.